This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi everyone, welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed. We are reading through the Menendez brothers retrial, 1996 retrial. We are going to go through the morning portion of Thursday, January 25th, 1996. And before we get started, I just want to apologize for the fact that there's been a pause, obviously, in my videos. I had a severe flare-up of my POTS, which is like post orthostatic tachycardia something, I don't know. And it basically, my heart beats super fast just to have to like sit up and be alive more so than a regular person. And my blood pools. It's like it's a weird thing. Like your blood pools in your legs and then your heart has to work harder to get it up to your brain. Anyways, that's what I'm being treated for right now and evaluated for. And it's been rough. I had a severe flare up from the 90-degree weather we had here in Chicago, and then that finally, like, I cooled off and I started to feel better, not entirely, and then I had like another second flare, so that kind of sucked. So I'm back. What you had this week was my pre-recorded when I started feeling better, but then I got my second flare, so I'm all caught up. Normally, with my recording schedule, I like to be a week ahead, a whole week. So I have the buffer for when something like this might happen. So I'm out of my buffer. And unfortunately, I'm out of my buffer. I'm all caught up with my recordings. So now I'm doing this, I'm recording this the same week that it's airing, just a couple days ahead of time. And I don't like that. I want to be way ahead because I can never account for what I'm going to feel like every day. So anyways, that's all I'm going to say about that. Advocate for yourself too when it comes to your medical stuff. I went kind of on a rant in my Frank's Memo Part 2 episode about advocating for myself and talking about my health symptoms and things like that. If you really want to know my health story, it's there. Not all of it, obviously, but a good portion of it. So anyways, I won't bore you with that anymore. Just want to apologize that my videos might be slow coming. It might take me a while to catch up to get to my previous recording schedule, and apologies for being off for the last week or so. All right, let's get to it. Let me shrink myself here. This is Thursday, January 25th, 1996. Judge Stanley Weisberg says the participants are here without the jury. Is there something you want to talk about? So right up front, we've got arguments without the jury. So Ms. Abramson says, yes, Your Honor. Good morning, Your Honor. He says, good morning. Ms. Abramson says, we want to offer certain evidence through this witness that the court has previously precluded. I would ask leave of court to allow my co-counsel, Ms. Towery, to argue the issue since her brain is working far better than mine today, and she's been pondering these matters for some time. So, although I am offering the witness, the testimony would be beneficial to both defendants, and therefore I defer to my colleague. The court says, sure. Ms. Abramson says, with the court's permission. Thank you. Ms. Towery, for Lyle, says, and Your Honor, we would also be offering the evidence that I am going to address on behalf of Lyle Menendez, and that is the evidence that we have previously discussed with the court, the fresh complaint by Lyle Menendez to Diane Vandermolen, which the court has previously ruled we could not elicit. I would ask that the court reconsider its ruling based upon the additional testimony that's been received since we made the argument, most specifically, Kathy Simonton's testimony about Jose Menendez going into Lyle's room with Lyle and no one else being allowed to go down the hall or into the room when Lyle was a young boy. And that is exactly the same as Erik Menendez's testimony about what happened to him when Jose was molesting him. So there is additional evidence which would support the inference that Lyle Menendez was molested by his father. Also, Dr. Wilson testified about and relied upon a sexual acting out by Lyle Menendez with respect to Erik Menendez when he was a little boy, and indicated that such acting out would be consistent with the actor having been molested, the actor being Lyle Menendez. I think he said that earlier. Ms. Abramson indicates she is not sure. The court says, I don't recall that. Ms. Towery says, all right, I will see if I can find it in the testimony, but I could be erroneous, so she could be wrong. In any event, he would so testify if permitted by the court. Given the prosecution's attack on Dr. Wilson's testimony as to the credibility and believability of Erik Menendez's statements that his father molested him, I think that we should be permitted some leeway to corroborate Erik Menendez's testimony in this regard. So we do have a number of references now to sexual molestation of Lyle Menendez by Jose Menendez. We have the references in Erik Menendez's testimony, which we provided to the court previously, which the court found too vague to permit the fresh complaint to come in directly on behalf of Lyle Menendez. But nevertheless, there are numerous references to Erik Menendez's belief that Lyle Menendez was sexually molested by his father, and there is certainly a reference, whether vague or not, to Lyle Menendez telling Erik Menendez that fact, and that certainly is a reasonable interpretation of Erik Menendez's testimony regarding the conversation in the car on the way to San Diego between himself and his brother. So we have that piece of evidence. We also have the nude photographs of both Lyle and Erik, which I believe that Dr. Wilson has and will continue to rely upon as a basis for his opinion in the case with respect to the sexual molestation of Erik Menendez. We also have what either has been offered or will be offered regarding Lyle Menendez's sexual activity with his brother when they were little boys. And finally, we have, as I mentioned before, the testimony of Kathy Simonton with respect to Lyle being taken into his room by his father and no one else being allowed to come in, which is exactly the same MO as Jose Menendez used with Erik Menendez when sexual molestation was occurring. So I ask that the court reconsider its ruling at this point in the trial and permit Ms. Abramson to ask Dr. Wilson his opinion regarding this fresh complaint and how that would factor into his evaluation of Erik Menendez's recitation of the sexual molestation, which, of course, Dr. Wilson has testified was the primary trauma to Erik Menendez. So basically, they want him to, there's this new complaint to one of the cousins, Vandermolen, Diane Vandermolen, and apparently the judge has already denied it, but they're trying to renew their motion to allow it into trial. And totally lost my train of thought because my dog is upstairs and I don't know what he's doing. I gotta go check on him. But so he's what was I gonna say? Oh, they want to ask Dr. Wilson, the defense wants to ask Dr. Wilson, how does this all fit into it? This new complaint and the fact that, it all corroborates things that Erik and Lyle have testified to. How does that, I cannot think of words right now. Blah. Basically analyze that and what does that mean as far as his sexual molestation? Did it occur? Is it likely that, these things happened because there's multiple people reporting it? There's corroborating, witness testimony. So there's that. Let me go check on the dog. I'll be right back. He was eating tissues out of the garbage can because that's what he likes to do. All right, moving on. I would ask that the court consider this to come in as a basis for the expert's opinion and also under 1103 of the Evidence Code, which would be specific instances of conduct by Jose Menendez to show his conduct in conformity with his character or trait of character and with respect to Erik. Menendez, and also to corroborate Erik Menendez's testimony with respect to the sexual molestation. So, hold on. Let's get readjusted here. Okay, he's just going to take the bone and leave. Fine. He didn't want to lay with me. Sorry. To show his conduct in conformity with his character of or trait of character with respect to Erik Menendez, and also to corroborate Erik Menendez's testimony with respect to the sexual molestation. So I would again ask the court to reconsider the admissibility of that piece of evidence, both with respect to Dr. Wilson's testimony and with respect to our ability to present the evidence through Diane Vandermolen by recalling her. I have another area that I'd like to address. Ms. Abramson says, I just want to call the court's attention to the matter in which the prosecution opened up this area, in my opinion, by asking Dr. Wilson if what the prosecution calls the molestation of Erik Menendez by Lyle Menendez could be the cause of Erik Menendez's post-traumatic stress disorder. I think that it behooves us to indicate that, in Dr. Wilson's opinion, Lyle Menendez's behavior was a sexual acting out by a sexually molested child and was not in a traumatic setting for Erik Menendez. And I think that the people have raised a red herring to try to shift the responsibility for Jose Menendez's acts onto Lyle Menendez, which is a very pernicious theme. You get what they're doing? They're making Lyle the monster instead of Jose, making it like Lyle's the child predator, not Jose, just Lyle, because he did things to his brother, acting out the things that happened to him by his father, which is a very common thing that children do. Because they don't understand what's happening, they can't process it. They reenact it. I think that the people have raised a red herring to try to shift the responsibility for Jose's acts, which is very onto Lyle. And I think that we should be entitled to show that Lyle Menendez was a victim of sexual molestation, and that's why he was behaving the way he did at 8 years old, and to disabuse the jury of the notion that he's the molester in this case. And Dr. Wilson will offer his opinion that this kind of sexual activity between an 8-year-old and a 5-year-old does not rise to the level of trauma as the activity that between a parent and a child involving violence, such as was testified to by Erik Menendez. But more important, the court cuts her off and says, that latter opinion certainly doesn't require all this other. Ms. Abramson says, I understand that, but more important, it's always been a basis for Dr. Wilson's opinion that Erik Menendez suffered PTSD as a result of sexual molestation at the hand of his father, that his opinion has been corroborated by or is partly in reliance on the fact that Lyle Menendez's acting out behavior indicated that Lyle Menendez was molested, that Lyle Menendez's fresh complaint to Diane Vandermolen was further support of the notion that Lyle Menendez was molested, and that bears on the character and behaviors of Jose Menendez. The court says, okay, and do the people wish to respond? First of all, is that it by you, Ms. Towery, on that subject, or was there something else? Ms. Towery says, on this subject, I did want to re-raise our offer of proof with respect to the same witness, but with respect to different testimony, and that is the sexually inappropriate behavior by Mrs. Menendez, Kitty Menendez, towards Lyle Menendez when he was 15 years old, and that specifically, as we have previously discussed, was her washing his hair in the bathroom and permitting him to sleep with her at the age of 15 when Jose was out of town. I introduced that. I believe that when I presented this to the court previously, I argued the testimony which the people elicited from Jamie Pisarcik regarding Lyle Menendez's admissions to her and his statement that his mother molested him. And I noticed in reviewing the testimony of Carlos Baralt, who was also a witness called by the prosecution, that Mr. Khan elicited on direct examination from Carlos Baralt whether or not Mr. Baralt had ever seen Kitty Menendez act in a sexually inappropriate manner towards her sons, or Lyle Menendez, to which Carlos Baralt responded that he had not. And Mrs. Menendez, on cross-examination, asked the specific questions regarding the behavior to which I refer, that is, washing the hair of a 15-year-old boy in the bathroom, and Carlos Baralt responded that he thought that that was inappropriate. That would be sexually inappropriate behavior on cross-examination. So we raised the issue of this specific conduct before the jury, and I would ask that the court reconsider its ruling on that basis. And I apologize for my failure to have remembered that particular testimony when making the offer of proof to the court, but I would re-raise that offer of proof based on that testimony. And since it is the same witness we're talking about, it certainly would not be inconvenient to have her testify to those two discrete areas if she is permitted to come back to testify with respect to the fresh complaint. Court says, okay, people want to respond, and you betcha they do. Mr. Khan says, yes, I think that the defense has no basis to argue that the prosecution opened up the door to any of the things that they are proposing. They are suggesting that because I asked questions concerning Erik Menendez and his alleged diagnosis of PTSD, that therefore it opened up the door to something concerning Lyle Menendez. It simply doesn't follow. Even though I made reference to Lyle Menendez when I asked, it is possible that the molestation by Lyle might have caused the PTSD. That does not in any way, shape, or form open up the door to what would be, in effect, now giving an opinion concerning whether or not Lyle Menendez was molested or whether there is evidence that Lyle Menendez was molested. They just don't want it in. That's the thing. Like, there's no reason why it can't come in. They just are fighting so hard not to have it come in. That is not something I even came close to in any of the questions that I asked the witness. The court already ruled that this witness can't even give a diagnosis that someone was in fact molested. He made a finding as far as Erik Menendez and made reference to that, but there is no basis upon which he can make that determination. Certainly he can't do it for Lyle Menendez. So this testimony is improper expert opinion. It should be excluded because the prosecution did not open up the door in any way, shape, or form. The same reasoning applies to the so-called fresh complaint. The fresh complaint is offered only for the purpose of corroborating a claim of the defendant himself who takes the stand and testifies. They are trying to backdoor the court's ruling when the court clearly rules that this is an inadmissible area if the defendant does not testify. So I should submit that once again there are no questions that the prosecution asked that should cause the court to change its ruling in that regard. It was inadmissible before, and it's still inadmissible now. And as far as the behavior of Kitty is concerned, I don't recall Carlos Baralt testifying it was sexually inappropriate behavior. I recall him testifying to just the contrary, that there was nothing sexually inappropriate, inappropriate about a mother going in and washing the hair of her 15-year-old. Well, it is if he's nude. There is something inappropriate about that. If she's going in the bathroom and checking his genitals, for instance, because she was doing that too. So that is inappropriate. And not allowing him any autonomy, any privacy, any space for himself. And so I think this is another area that is inadmissible and simply not relevant at this point in time, particularly in light of the fact that the defendant, Lyle Menendez, has not taken the stand and made any allegations of sexual abuse by his mother or by his father. This behavior of obviously sleeping in the same bed with his mother on one or more occasions, or his mother going into the bathroom to wash his hair, simply does not prove sexual assault. And even if it was circumstantial evidence of sexual assault, which it was not, it should be excluded under Evidence Code sections 350 and 352. Court says anything further. Ms. Towery says, just briefly, Your Honor. The offer is not for Dr. Wilson to opine that Lyle Menendez was sexually molested by his father. The offer is to permit Dr. Wilson to take into account these separate pieces of circumstantial evidence, or I would submit direct evidence with respect to Erik Menendez's testimony, and to let him make those pieces of evidence into account, to take those pieces of evidence into account in his evaluation of Erik Menendez, and then in his evaluation of the credibility of Erik's claims of sexual molestation. I believe, and I am submitting to the court, that all of these separate pieces of evidence, perhaps independently, don't lead to the conclusion that Lyle was molested, but certainly together a reasonable inference that can be drawn from all of these pieces of evidence is that that was the case. And again, the purpose is not to have Dr. Wilson testify that that is his opinion. The purpose is to permit him to take the specific incidents into account in his evaluation of Erik Menendez, and also to permit us to prove up the underlying facts because Dr. Wilson's opinion with respect to the sexual molestation of Erik Menendez has been attacked directly by the prosecution. And again, I can provide the court with a citation to the testimony of Carlos Peralt. Court says, I don't want to get into that. He testified about some things that were and were not, in his opinion, inappropriate sexual conduct during this cross-examination and direct examination, and it's in the record. I accept your recollection of what it was, and there were some specifics as to what it was alleged that Mrs. Menendez did in regard to Erik Menendez and also Lyle Menendez. I recall basically what it was. The purpose of Dr. Wilson's testimony about the sexual molestation is twofold. One was, as an expert generally, to describe what is referred to as symptoms of child sexual abuse accommodation syndrome, to corroborate testimony of the defendant. In general, this was discussed. This was brought out during offers of proof that he would describe the manner in which the defendant disclosed his sexual molestation and the symptoms and behavior that he displayed, that this is not unusual for someone who has been sexually molested. That was part of the offer of the evidence. He is not from that permitted to testify. He is not from that permitted to testify that the defendant was molested. He is not from that then allowed to testify. Okay, it's just a weird way of wording it. He's not allowed to testify whether he thinks either of the defendants was actually molested. This type of evidence is just generally offered once the credibility of the alleged victim of molestation, that credibility is attacked and that testimony was presented. The other offer and the reason for his testimony being introduced was to be a basis for a diagnosis of post-traumatic stress disorder. Again, Dr. Wilson would not be permitted in an ordinary sense to testify in his opinion that the defendant had been sexually molested. The only reason the evidence is relevant at all is as a basis for his opinion that the defendant suffered from post-traumatic stress disorder and that these symptoms, the byproduct of that disorder, affected the defendant's mental process at the time of the crime in this case, and that is the purpose of his testimony. As I said before, the way the defense is presented here and the significance of the sexual molestation is not just as a basis for the opinion of Dr. Wilson. There is an independent role that sexual molestation plays in the case as part of a factual scenario that the defendants present to the jury what happened that week before the killing of the parents, and that's a factual issue for the jury to decide whether or not there was sexual molestation of Erik Menendez. That's not the purpose for which Dr. Wilson testified, and his testimony is not being received for the purpose of establishing that Erik was, in fact, sexually molested, but only his opinion in that regard is only received as a basis for his opinion regarding the symptomology of post-traumatic stress disorder. Whether or not Erik Menendez was sexually molested is a question of fact for the jury to decide as part of their overall decision-making in this case, to evaluate the fact scenario presented by the defendants of the sexual molestation, the disclosure of it, the threat to disclose it to others, and what role that played in the relevant events of that week. That's for the jury to decide, and the danger here of permitting Dr. Wilson to inject his opinions about whether Lyle Menendez had been sexually abused and the role that plays in the overall scenario. The danger is that the jury would then be put in a position of considering that evidence in the context of whether or not Erik Menendez had been sexually molested, whether or not Lyle had been sexually molested, and the danger is that that evidence no longer is received for a basis of an opinion by Dr. Wilson, but is received for the truth of the matter that these events actually occurred. What? Who cares? He's not saying that. And you can have a jury instruction for that. Like, why is this such a big deal? He can't talk about the fact that the brothers were molested. Yes, okay. He can't say, yes, I know for sure it happened. No one can. But that's not what he's doing. So this is so stupid. Do you see how they twist? Judges will twist and turn anything to make it like, nope, that can't come in. And I don't need to give my reasons, but here's a really twisted reason that makes no sense to normal people. It's crazy. I need more water. Part of this POTS thing is you have to drink electrolyte water, like salty water with electrolytes, and a lot. I drink a lot of it. Anyways, where was I? So received for the basis of the truth of the matter that these events actually occurred and that these molestations actually occurred. And the way to prove those things is through the testimony of the participants. We've had Erik Menendez testify about molestation. If Lyle Menendez testifies about molestation, the other material might or might not be corroborative of his testimony. But at this stage, the court is balancing the need of the defense to present the expert testimony, and contrary to the complaints of the defense, the expert has been permitted to testify broadly and widely on the subject for which he was called, and to express his opinions and the basis for his opinions. At the same time, the court is balancing that need against the danger of impermissible and incompetent hearsay evidence coming before the jury that would then be used by the jury for the truth of the matters asserted, and that danger is such that the court was satisfied when I ruled on these subjects earlier that they are irrelevant, and under Section 352, the probative value is potentially outweighed by their potential for prejudice. I am satisfied that those rulings are still the proper rulings in the context of this case. He is such a liar. Why? Why can't Dr. Wilson say, yeah, I've evaluated the things that Lyle said in his testimony too, and it corroborates everything that Erik said. What's wrong with that? That's what experts do. They're limiting him so much that he's not effective. This is the judge's fault. 100%, I blame Judge Weisberg for this. I am satisfied that those rulings are still the proper rulings in the context of this case, as it has been presented, and nothing that has occurred during the direct or the cross of the witness causes the court to change its view in this regard. Ms. Abramson says, Your Honor, I would just point out one thing, which is that we're not in a position to call the participants in trying to prove our case. The fact is that was an important factor in Dr. Wilson's being able to render an opinion as to the causative nature of Erik Menendez's PTSD. The prosecution has tried to distort the significance of that very same evidence, the acting out behavior by Lyle Menendez. They need to clear it up. They need to fix that. I am not in a position where I can call Lyle Menendez to testify to that one event. The court says then Ms. Abramson cuts him off and says, I mean, in this narrow issue, it is no different than this piece of evidence, although it is more interesting than some of the other pieces of evidence that Dr. Wilson has relied upon. It is no different in the sense that the jury will be instructed as to what use they can make of the evidence. But what is difficult for me to think my way through, and more importantly, for me to, in fact, plan a defense around, is the concept that for this particular fact or set of facts, the only appropriate proof is to have the co-participant Lyle Menendez testify. And yet, for some of the other facts that Dr. Wilson has been relying on, we're not permitted to call the participants to testify. In other words, if what I'm hearing, the court says there is no dispute about those things. He's been testifying about things, and the people haven't controverted or disputed those things. They've just accepted them. Ms. Abramson says, I think they disputed the relationship between Erik Menendez and his mother on the cross-examination of Erik. It's just that they've disputed all of it with other witnesses. It doesn't mean that they had to do it with this witness. It's just that we're stuck now with evidence coming only from Dr. Wilson, which the jury can't rely on, if I am understanding the court properly, for the truth of what those witnesses said in their statements or in their proper testimony that Dr. Wilson is relying on, and we're not permitted to call him for the truth. Whereas this piece of evidence, which is only being introduced to show the strength of Dr. Wilson's opinion, or the basis for his opinion, we can only prove by calling the witness so it comes in for the truth. So I am not trying to be cute, but I am puzzled. I am puzzled now as to what can I get up at the end of the case and argue is truth in this case in front of the jury versus what's openly come in to support an opinion. I'm getting old. I can't do these things very easily anymore. I just want to say this was 1996. She really didn't even retire until just a few years ago. So she's been like heavy at it and doing like lawyering court stuff for up until she was in her 80s. She's just recently retired. The court says, well, I would say if the expert has testified to something that he considered and it's never been disputed in any way by the prosecution, then clearly that's part of his opinion. Now, that's without dispute, and it's something you can argue to the jury that there has been no dispute about these underlying symptoms. Somebody described a certain behavior of the defendant at a certain time. That's not been disputed. So, since it hasn't been disputed, it is something the expert is certainly permitted to consider. Ms. Abramson says, I think it's more, though, than just the behavior of the defendant that's formed the basis of his opinion. Remember, he's also talking about battered person syndrome as one of his diagnoses, and for that purpose, he has testified to the environment, the terrorizing and controlling and otherwise maltreatment-ridden environment in this family. The court says, we are now getting beyond the discussion we are having. Ms. Abramson says, I think the point is that I recognize that this particular piece of evidence is more persuasive, let's say, or more prone to elicit a reaction from a jury in hearing it. But I don't think that alone is enough reason to keep it out when other information equally unproven by the participants has been allowed to be elicited from Dr. Wilson, and appropriately so. And just one other thing, Your Honor, I just want to make the record clear that we have not offered to introduce evidence of child abuse accommodations syndrome. That's not it. We are trying to introduce evidence of battered person syndrome based on child abuse. The court says, okay, I am referring to the child sexual abuse accommodation syndrome, the type of behavior, the way a child behaves after having been abused, and you offered that as a general way of dispelling misconceptions, and that was presented. Now, whether that is part of a post-traumatic stress disorder symptomology or some other syndrome that has been utilized in other contexts, that's what I'm referring to, and you are permitted to introduce that. Ms. Abramson says, I understand you're using that as shorthand for the other, Your Honor, but child sexual abuse accommodation syndrome includes features that have no relevance here, and we're not dealing with, at all, issues such as children changing their story and refusing to testify and wanting to protect their abuser. None of that has any relevance. The court says, there are features of a similar nature to which you offered here, and that really was what I was referring to. All right, anything else at this point on these subjects? We are just waiting for a juror who had a personal matter to deal with. Mr. Levin says, Your Honor, just 1 second. The court says, let's take a break here. The lawyers don't need to leave the courtroom unless it's a matter of personal necessity, because we want to start as soon as the jurors get back. They take a 10-minute recess. The court comes back and says, okay, everybody is back and we'll have the jury out, please. Ms. Abramson says, Judge, I know we're starting late, but I will need a recess. I'm not feeling well today. I apologize. In about an hour, just midway. Thank you, Your Honor. The court says, all right. The jury enters the room. The court says, we have the jury back. Good morning, and we are ready to resume with the testimony of Dr. Wilson. You're still under oath, and we are in redirect examination. Ms. Abramson says, thank you, Your Honor. Mr. Wilson resumes the stand. Dr. Wilson, before you came to Los Angeles in July of 1995 to testify in the pretrial hearing, have you and I ever met? No. Before you came to testify in that hearing, were you asked to examine all the literature and all of the research on PTSD's, post traumatic stress syndromes, as they related to interpersonal violence? Yes. And in preparing for that hearing, did you focus on the research materials and what was being commonly understood to be the effects on people of maltreatment at the hands of other people? Yes. With respect to this case, was the only testimony that was submitted to you before that hearing the testimony of Dr. Burgess and Dr. Conti from the first trial? Yes. And those were experts who testified for Erik Menendez and Lyle Menendez, respectively, at the first trial concerning effects of maltreatment on them. Objection irrelevant, calls for hearsay. The court says sustained as to the content of any testimony. Objection sustained. Ms. Abramson says they were testifying as psychological experts. Objection irrelevant, overruled. The witness says yes. Ms. Abramson, why do I keep calling her Wilson? Or Williamson. I don't know. Sorry. Ms. Abramson says, you did not have any statements of Erik Menendez at that time or any testimony of his? No. You did not have any testimony or any statements of his family members, coaches, teachers, friends, any of that? No. You didn't have the facts of this case. Is that correct? Correct. And is that testimony at that hearing in that testimony at the hearing, you didn't testify with reference to facts in this case. Is that correct? Correct. And when you gave your testimony, did you take a sort of overview of the whole history of research on traumatic stress syndromes? Yes. Did you give any examples in that testimony of how these symptoms might manifest themselves that you later heard parroted back to you by Erik Menendez? No. Now, after you completed your testimony in that hearing, did you, 3.5 weeks after that, did I broach with you for the first time the possibility of you becoming a mental health expert in this trial? Yes. And after that conversation, and do you remember if that was in, what month was that in? August, I believe. And that conversation took place where? It was first on the telephone. And then a meeting later that day? Yes. In what city? Los Angeles, I believe. Do you remember? Oh, I'm sorry. No, we were in New York City. That's right, New York City, excuse me. And you and I and Mr. Levin had a meeting at which we discussed the possibility of your being an expert in this case. Over dinner, says the witness. Ms. Abramson says, and after that meeting, were you sent for the first time Erik Menendez's testimony from the first trial? Yes. Would you read Erik Menendez's testimony from the first trial? When you read it, did it contain factual information identical to what he told you when you interviewed him? Yes. So he's consistent there. Did it contain factual information concerning feelings and thoughts and experiences and behaviors on his part that you ascribe now as symptoms of post-traumatic stress disorder? Yes. And at the time that you received that testimony in 95, had 2 years passed since Mr. Menendez had so testified? Yes. And subsequent to receiving that testimony, did you also receive a large quantity of materials consisting of testimony, witness statements, document notes from Dr. Vickery, documents, notes from Dr. Vickery, school records, medical records, therapy records of Mrs. Menendez, and other materials that you have examined and relied upon in forming your opinion concerning post-traumatic stress disorder? Yes. Was all of that material that you received compiled in existence, if you know, before we ever had a hearing in which you were a participant? Yes. Now, with respect to the process that you used in forming your opinions that you have testified to in this case, before you interviewed Erik Menendez, had you ever reviewed anything other than his testimony from the first trial? No, I hadn't. And you have indicated that you had a very lengthy, well, strike that. You indicated that you had 2 sessions with him on that first day? Yes. And are those reflected in the notes that you labeled tablet 1 and tablet 2? Yes. Excuse me, I had a cough there. The tablet 1 is 50 pages long? Yes. Tablet 2 is 45 pages long? Yes. How many hours? And this was all done on September 30th, 1995. Yes, between approximately 10:20 in the morning and about 10 minutes to 5 in the evening with a short break in between. Ms. Abramson asks, and you said that after having interviewed him and having already read his previous testimony, you came to some conclusions regarding a possible diagnosis. Yes. And that possible diagnosis at that time was what? Post-traumatic stress disorder. Now, was that a conclusive diagnosis at the time? He met the diagnostic criteria for PTSD at that time. So it was conclusive. Yes. All right. Were you then submitted, uh, were you then submitted this large body of other information, witness observations, statements, testimony, all the things we've talked about? Indeed. And did you read them? Yes. Did you read them carefully? Yes. If in those materials you had not found any corroboration for the information that Mr. Menendez had given you, would you have stuck to your diagnosis? I may have stuck to the diagnosis because his account was so explicit and so clear that he clearly met the diagnostic criteria. However, with no corroborating evidence, I might have had to be suspicious about some aspects of his account. Did you find corroborating evidence in all of those materials that were submitted to you? In a lot of it. And in cases that you evaluate, are you always in a position where there is a lot of corroborating evidence? Not this much. Is this case unusual in the amount of corroborating evidence that you had access to? Yes. There's more corroborating evidence of sexual abuse in this case than any other case that we know of right now. Now, since you had a diagnosis after that first marathon interview and after you had corroboration, after reading all those reports, why'd you go back to see him again and again and again? I wanted to go back and to continue to pursue in depth many of the things that we had talked about in the first interview, in particular, the issues of sexual molestation, and in particular, his account of the last week of August the 20th, 1989. So those are matters that you talked to him about on more than one occasion? That's correct. Those were things that you kept going back to? That's correct. Was there any concern on your part to continue to see him and continue to review materials because it was a forensic case? Yes, of course. And the DSM 4 says you have to take special care. Yes. If you had just been screening him for clinical purposes for treatment, do you think you would have needed those additional interviews? No. You would have been confident to begin treatment for post traumatic stress disorder based on what you knew after his first interview. Yes. When you've done evaluations in the past, have you had the benefit of evaluations done as long as 6 years prior by other qualified mental health experts to bolster your opinion? Yes. And did you have that here? Yes. Mr. Khan says, objection, calls for hearsay, improper expert opinion. The court says, sustained as to the form of the question, answer is stricken, you may rephrase the question. Ms. Abramson says, okay. In this case, did you have the benefit of interviews and evaluations that were done, first of all, by a forensic psychiatrist, Dr. Vickery, back in 1990? Yes. And was that one of the things upon which you based your ultimate opinion? Yes. One of many things. Yes. Did you also have the benefit of consultation and communication with Dr. Stuart Hart? Yes. And do you know how long Dr. Stewart Hart was involved with this case? Well, what he's reported to me is over 600 hours of his time. I don't know what that relates to in numbers of years. Do you know what year it was that he first became involved in the case? I'm not certain. Do you know that he has performed evaluations or assessments, if you recall, of issues of psychological maltreatment concerning the Menendez parents and the Menendez sons? Objection, irrelevant. Sustained, says the court. Ms. Abramson says, did or is it your understanding that Dr. Hart personally interviewed many of the witnesses whose statements and testimony you reviewed? Objection, irrelevant. Overruled. The witness says yes. Ms. Abramson says, and did he share with you information that he had obtained from those witnesses that didn't appear in written reports? Yes. Was it your understanding that Dr. Hart had spent many years interviewing Erik Menendez? Yes. And in discussing, did Dr. Hart, along with yourself, compile factual data obtained from Erik Menendez and other witnesses concerning some of the features of the Menendez family that you relied upon in forming your opinions of PTSD and battered person syndrome? Yes. As a consequence of working with Dr. Hart, did you determine that the information that he had received from Erik was consistent with what you were receiving? It was. Now, was the last thing that you did in preparing to offer your opinion to this courtroom, in this case, the administration of the 4 tests that you testified about? That's correct. And had you long before the administration of these tests form your opinion of post-traumatic stress disorder and battered person syndrome? Yes. Did you need the tests to? No. To diagnose? No. Would you ever diagnose just based on those tests? No. Or any tests? No. In your opinion, is the testing as important as the clinical evaluation and all of the corroborating information? I'm sorry, is it as important? For the purpose of forming a diagnosis. The witness says it's one part of a composite process to form a diagnosis. And in this case, however, you indicated you formed your diagnosis before you gave the test. Correct. Why'd you give the test? I wanted to give a quantitative measure, so he wanted to quantify, put it into numbers, of his post-traumatic stress disorder symptomology. First of all, I wanted to use quantitative measure of how his post-traumatic stress disorder symptomology and a few of its features as self-reference and compare it with profiles for people who have been diagnosed with PTSD. Number 3, I wanted to see the quantitative expression or manifestation of those symptoms in an empirical form, a quantitative form, to get some idea of the severity and intensity of his post-traumatic stress disorder state as measured by standardly measured instruments in the field of PTSD and in clinical psychology. Would it be fair to say that you had formed the opinion that he had post-traumatic stress disorder and the test helped you decide how bad it was? Yes. Now, in concerning those tests, and particularly the one that we charted, I think it's back here. I have a copy on the floor. Excuse me, everyone, for a moment. I'm not finding something, Your Honor. I'm sorry. Ms. Tennell, are there any charts on the other side of the courtroom? Anything over there? Let's talk while Mr. Levin is looking. The witness says, go ahead. Ms. Abramson says, let's keep going here. Okay. Had you testified that Mr. Khan asked you a whole series of questions about whether, if somebody wanted to, they could lie in answering a question on these tests? Yes. And of course, anybody can lie, correct? Sure. Children can lie? Sure. These tests weren't, however, designed by children, were they? No. And when they were they designed with a view to try to bust lying? Yes. So they were basically, the wording was formatted in a way that would try to prevent people from lying on the test. That's what she's saying. Is that what's called validity scales? Yes. And do most psychological test instruments have validity scales? Many of them do, and many don't. And the ones that had validity scales, do those tend to become the standard measures? Yes, because they're the most trustworthy. Yes, the validity scales are designed to detect the test taking attitude of the person responding to the test. And is trying to make yourself look bad a test taking attitude that the validity scales are designed to reveal? In some tests, it is. In this test, it has 3 validity scales, and one of them looks at inconsistency in responding. Is there an assumption that the test is designed in such a way that a person who hasn't studied it and isn't familiar with it, if they're lying, it would show inconsistency in their answers? Yes. Now, these tests, I think you've indicated they're supposed to show the severity of symptoms. It can, correct, as well as the existence of symptoms. That's how it's designed, psychometrically, correct. It's designed to measure all the symptoms that the patient is having. Ms. Abramson says, and if someone wanted to appear really, really sick, could they just answer the highest severity for all the symptoms for every question? Yes, they could. And they would have a real high spiking profile across the board. They would. Did Erik Menendez do that? No. Did he do that even with respect to just those clusters on the TSI, which is the graph we're looking at right now that measure post traumatic stress disorder? No. So he didn't even come across as high extreme in every category of PTSD? Well, no, he didn't. That's correct. In fact, in some things, he's lower, slightly lower than the standard PTSD profile. Yes, we noted defensive avoidance the other day. And that's a very common symptom of PTSD. Like you don't want to, if someone comes at you and like your first response is to defend yourself, you're going to avoid a confrontation. You're going to avoid having to, even defend yourself possibly. You might just, take it in stride and be like, okay, whatever. That's what I think that's about. That might technically not be the psychiatrist's term or the psychology term, but that's what defensive avoidance sounds like to me. When you avoid instances where you would feel like defensive, you need to defend yourself, which is kind of what they were talking about here too. And that's a very common symptom of PTSD. He says, yes, that's the C cluster in the manual. In fact, says Ms. Abramson, the tendency, if you're very high in intrusive imagery, you're not going to be high on avoidance. No, you can be high on both. You can. So there isn't even any guidelines to someone as to how to choose between those two or how to come up with a consistent result for PTSD. For the person taking the test, that's true. And you didn't did you tell Erik Menendez before you gave him these results, number one, that you were even going to give him tests? No, he didn't know. And did you tell him what tests? No. Did you even show me what tests they were? No. So he didn't even go to Ms. Abramson and say, I'm going to do these tests. He just did it as part of his evaluation. Objection irrelevant. Overruled. The witness says, no, I didn't show you either. Ms. Abramson asks, Well, did you even discuss this with myself or Mr. Levin or anyone else associated with the defense, first of all, that you were going to give him these tests before you gave the tests? Objection, says Mr. Khan, and the court overrules that. The witness says, it was my decision alone. Correct. Abramson says, and you didn't tell us? No, I didn't tell you. Until afterwards. That's correct. When we said, oh, really? How'd he do? That's correct. That's what you said. And then you showed us the test for the first time? Correct. Now, the interviews that you conducted with Mr. Menendez and that Dr. Vickery conducted before you ever gave him the tests revealed intrusive thoughts and other symptoms that he demonstrated in the test results, correct? Yes. And in fact, his testimony from the first trial revealed the same? Yes. Now, I want to, now some of these, okay, that's error, a spelling error there. Some of these tests were meant to measure a lifetime of symptoms and a lifetime of thought processes, correct? The CAPS test we refer to. And others are supposed to measure things in the previous 6 months. Yes. Thoughts or feelings or attitudes in the previous 6 months. Yes. Another test was supposed to measure thoughts or feelings or attitudes a week before the test was given. Correct. And you used that particular test to also measure thoughts or feelings or attitudes the week before the shooting occurred? Correct. Okay, I want to change now and talk a little bit about your notes and focus on this. Mr. Khan, I think, called your attention to 2 pages of your 260 pages of notes. One of them contained a conversation that you had with Erik concerning his changing perception of his mother after his decision with her, after his discussion with her on Thursday night before the homicides, in which she basically told him that she knew what was happening to him and didn't care, meaning she knew about the molestation and she just didn't do anything to prevent it. She was complicit in it by not doing anything to stop it. The witness answers yes. And in that conversation, you wrote down that he used the word vampire? Correct. He didn't use Dracula. No, the word was vampire. Vampire. What is a vampire? Objection, irrelevant, sustained. Is a vampire a creature that changes shape from one thing to another? Objection, irrelevant, no foundation, sustained. This was the word used by Erik Menendez, is that right? Yes, it is. I also think of a vampire as someone who drains you, sucks your energy. So it's very possible he means more like she was draining him of his positive energy or something. You know, a lot of people can do that. There are energy vampires out there, and narcissistic abusers tend to fit that category. Where was I? That was the word used by Erik. Is that correct? The vampire. He says yes, it is. The court asks, is that correct? Did you ask him to define the word for you? The witness says no. The court says okay, then that's it. Ms. Abramson says, in the context in which he used that word, was he analogizing it to something? Objection, calls for speculation and conclusion. Sustained. That's garbage because if you're using a word to describe somebody, you should be able to say that you're analogizing it to something. But Ms. Abramson says, did he use the word in context of explaining how radically his perception of his mother changed that night? Objection, improper expert opinion, says Mr. Khan. The court says, well, sustained as to the form of the question, it's also leading. Ms. Abramson says, what was your understanding after talking to him for hours at the time that the word was used, correct? That was, what? What was your understanding after talking to him for hours at the time that word was used, correct? Yes. Maybe she said that was your understanding instead of what was your understanding. And it's just an error there because that question doesn't make sense as worded. And what did you understand he was conveying to you in the context of that discussion by using the word vampire? Dr. Wilson says it was his perception and image of his mother that had changed at that point in time because of the revelation that she knew about the abuse. Changed from what to what, says Miss Abramson. From hoping and wishing that she didn't know about the abuse, that she was blind to it, to revealing to him that she did in fact know. Why would he hope and wish that she was blind to it? Because if she was blind to it, I'm gonna speculate here, but I think in his mind, if she was blind to it, then you can't blame her for not stepping in and intervening and stopping it. But if she knew and never did anything about it, your whole world is shattered because she was your safety net, and that safety net's gone now. So that's why it's so important that his view of her changes right at this point in time. Yeah. So if she knew, then like I said, she's complicit in all of the abuse, and he he can look at her now just as the same type of abuser as Jose because she didn't do anything. So in his mind, I'm sure it was devastating and very traumatic to find out that his mother, who he only hoped she didn't know because her not knowing, her ignorance means that she's innocent of it. But if she's not, and if she knew, then he has every right to feel betrayed and hurt by her. All right. So why would he hope and wish that she was blind to it? Of course, objection calls for speculation sustained. That is speculation, but it's okay to speculate sometimes. Maybe not in the court of law, but in life in general. Ms. Abramson says, well, why did he explain he was hoping and wishing that she was blind to it? Objection, assuming facts, not in evidence. Sustained. Ms. Abramson says, did he tell you he was hoping and wishing that she didn't know about it? Yes. Why? Because it was shocking to him to find out that she did know, that he had had this idealized image of his mother for many years and had this belief that she really didn't know about what was going on. So the revelation that she did know stunned him and shocked him. And it was at that point he was describing his change in perception of her. She went from a safety net to someone he could never trust, someone he could never confide in, someone he could never go to anymore when he needed that safety net. So his whole perception of her changes. When you say he described an idealized image of his mother, what do you mean by that? In that he always had this admiration of his mother, that he always was working for her love and tended to see her as a good person, even though she had faults. Did he indicate to you in your interviews with him that before this, whether or not before this Thursday night, he thought his mother loved him? Yes. And did he? Yes. And when this revelation happened, did he indicate to you that there was a change in his belief concerning whether his mother loved him? Yes. What did he indicate? He indicated that he wasn't sure anymore, that she seemed different to him. She was now threatening, that he wasn't sure whether she really loved him. Heartbreaking. That's heartbreaking for any child, no matter what age. You can be an adult and still have that revelation or something, that you think your parent doesn't love you. That's traumatizing. As And was the use of the word vampire, says Ms. Abramson, an example that he was giving you to convey something along the lines of threatening or to convey something else? Objection calls for speculation. Sustained. Did you discuss with him at any time his use of that word? No, I didn't. Why not? Because it was clear in the context in which he was using it. What was clear? It was clear that he saw her as a foreboding person at that point in time. That's a great answer because it's not really saying, like, it's not interpreting what vampire means, but it is giving just the fact that he uses the word gives the impression that she is a foreboding person. She is scary. She is, ominous in his life. This is not a person that you want to go toe to toe with. She's in a threatening manner. Well, in the rest of your notes, are there numerous references by Erik Menendez to his mother? Yes, of course. And does he describe her in many instances favorably? There is a mixture of adjectives, yes. Some are favorable and some are not. What are the unfavorable ways in which he described her? Hostile, rageful, threatening. What are the favorable ways in which he described her? Thoughtful. I'm sorry, not thoughtful. That's throughout. I don't know where that came from. My brain's working in slow motion today, if you can't tell. So, what are the favorable ways in which he described her? Throughout the corpus of my notes, there is, working for her smile, seeking her love. The times she would be positive. At other times, she was unpredictable and rageful. So, really, his only favorable interactions with her is when she smiles, and he's always seeking that smile. He's seeking that love and approval. That's how she shows her love and approval to him, is that smile. So he's always seeking that out. Did he express to you in these notes how he had felt about his mother? Yes. How did he express he had felt about her? He had mixed feelings. I mean, on the one hand, he loved her and sought to have her admiration and approval. And on the other hand, there is reference to her being unpredictable and hostile and threatening and words of those sorts. So, how did he feel when she was unpredictable and hostile and threatening? He was frightened. So, he loved her, but he was afraid of her? Yes, that sums it up right there. Probably sums it up with how he felt about Jose, although afraid would be probably too nice of a word. It would be like extreme terror and horror that he felt towards his father, but also loved him at the same time. Very complex, complicated human emotions that these boys are dealing with, and they don't have the mental wherewithal or capacity to understand it. Or tools or anything to deal with it. It's just putting them in a severe traumatic fight or flight mode all the time, which tends to then turn into hypervigilance, PTSD, and all the things. There are profiles of alcoholic parents and how they interact with their children. Objection irrelevant, sustained, says the court. Based on the research, do the children of alcoholic parents often love and fear in combination? Yes. Objection irrelevant. Overruled. The answer will stand. So good. I'm glad she got that in there because it does prove the point there. The witness once again says yes. Ms. Abramson says, is there also research about how the children of parents who are emotionally erratic and unstable both love and fear them? Yes. Now, the other page of your notes that Mr. Khan talked about was one in which you were apparently interviewing Erik Menendez concerning his purchasing the shotguns and what his mental process was about what the consequence of purchasing the shotguns were. Do you remember that? Yes. And Dr. Wilson, did you in fact talk to Erik on more than one occasion about what led up to the purchasing of the guns and the method by which they were purchased? Yes. Did you, in fact, talk to him on more than one occasion concerning what ID he used and what his concerns were about what might follow the use of that ID? Yes, I did. Did Mr. Khan only identify one of those references in your notes? Yes. Let's turn, if we can, to tablet 6, page 16. Tablet 6? Yes. Okay. And is tablet 6, page 16, a different reference to the very same thing? Yes. And this is an interview that was conducted on December 9th, 1995. That's correct. Now, back in September, when you talked to Mr. Menendez, did he tell you that he had lost his wallet and his ID before they ever went to San Diego to buy guns? Yes. In this interview in December, did Mr. Menendez say to you that even if he had had his own ID, he wouldn't have used it, that he would have been afraid that his father would find out if he got stuff like NRA magazines in the mail? Mr. Khan says, I would ask, do we have reference as to where counsel is reading from? The last sentence, says Ms. Abramson. That's what it says the witness. Ms. Abramson says, well, it says just word for word, these are notes, not a verbatim transcript, correct? That's correct, says the witness. Ms. Abramson says, it says, even if had own ID, wouldn't use, afraid dad would find out if got stuff, NRA magazines. Yes. Okay. Now, tell me what he was. That's smart for an 18-year-old kid, actually, to be thinking that. I don't know if I would have thought that at that age. Okay. Now, tell me what he was saying there. What do you remember the conversation, which I take was less cryptic than those notes? Yes. All right. The witness says, what Mr. Menendez was saying to me was that if he had a valid driver's license, he was afraid to use it because if he used it, it would identify him and his address. And he was afraid that that would have been the case, if that would have been the case, that they could get literature in the mail, such as a National Rifle Association subscription, application, or magazine, or other mail of that type, which might be associated with the purchase of a gun, and that's why he made the reference to the NRA magazine. Okay. And what was his concern? First of all, he seemed to think that if you buy a gun, the NRA sends you stuff. That's what he thought. Okay. I mean, that's not necessarily true, but you might get something in the mail, perhaps about gun ownership, because you might get on a mailing list and people might send you things. So it's actually a very smart thing that he was thinking. Even though you might not automatically get an NRA magazine, you might get some things in the mail showing, certain advertisements for things because you might get on a certain mailing list. So actually, I think that's kind of smart. The next question is, what was his concern about having and we're talking about the National Rifle Association. What was his concern about having the National Rifle Association send him applications, magazines? The court says, you're asking, what did he say? Yeah. Why was he concerned about that? He was concerned about it because it would come to the house and his father could discover that he had a magazine or a periodical that could be associated with having a weapon. And Dr. Wilson, is it implied in that statement if he was concerned that his father might see literature in that the NRA might send sometime after he purchased the gun that his father would be alive to see the mail? Yes, good point. Good point. He wasn't buying it to or put he was avoiding putting his own address on because he thought mail would come to the house, thinking his father would see it. No intention that his parents wouldn't be there in the future. Not thinking that. That's a really good question. A really good uh, point made by the defense there. Did Mr. Menendez tell you that at the time he purchased the gun, it occurred to him that even if he had had his own ID, he wouldn't have used it? Yes. because he didn't want his father to know from something that might be sent that he had purchased a gun. Objection leading, sustained. Wait, there is no question here. There is no question. Ms. Abramson says, did he tell you that the reason why the court says, why did he say, or what did he say the reason was? What he said the reason was, Your Honor, was he was afraid it could be traced. His father could trace it. And if his father could trace it, he would find out that he had done that. And he was really worried if his father found out that he would get in trouble because he knew his father would make an inquiry about why he would do this. Ms. Abramson says, You said your father, or I'm sorry, you said his father would trace it and find out. How would he find out? He would find out he was purchasing a gun. By tracing what? His subscription to the magazine, tracking down what he'd been doing. Well, did he say he subscribed to a magazine? No. So it's an irrational fear, but it doesn't mean that he wouldn't get stuff in the mail, possibly. So his father would track down why the mail would come to him? Yes. Like maybe contacting the NRA? Yes. Now, Mr. Khan asked you about whether you consider the activity that Erik Menendez described that occurred between himself and Lyle Menendez out in the woodpile when Erik was about 5 years old as being a cause of that extreme post-traumatic stress disorder profile that you have described. He asked me that. And did you consider that would have caused post-traumatic stress disorder that he would be experiencing 13 years later? I considered it. What was your conclusion? My conclusion is that it had nothing to do with his PTSD 13 years later. So the thing that happened with Lyle and Erik out in the woods, where Lyle was basically like recreating the abuse that he suffered from Jose on to Erik. But they were younger at the time and they didn't know, Lyle didn't know what he was doing and had severe regrets about it later when he was on the stand and was talking about it and bawling, choking up, crying, and Erik's crying, and the both of them are crying while Lyle's on the stand. It was a very emotional moment. And this doctor is saying it had nothing to do with PTSD because, you know what, the prosecution tried to infer that it did. So this expert says it didn't. And Ms. Abramson says nothing whatsoever. It had nothing to do with it whatsoever. He says none. And why is that? It's because the description of the activity between Lyle and Erik, in my view, was a form of sex acting out on the part of Lyle Menendez with his brother when Erik was about 6 years old. And why was it, in the way it was described to you and described in all previous statements about it, did it have any significant trauma component? Not that I would discern. And if that had been the source of trauma, would you have expected a whole series of symptoms specific of that trauma? Of course. And symptoms specific to that trauma, would they have involved fear of the person who inflicted the trauma? Yes. So he would have been afraid of Lyle, which he was not. He went to Lyle for help, so he wasn't afraid of Lyle. Is fear of the person or agency that inflicts the trauma the key ingredient of a trauma-specific symptom? Yes. And was there anything that you determined in all of the materials submitted to you that indicated that Erik Menendez had a fear of his brother? No. Was there anything that indicated that in his brother's presence he became fearful or frightened or hypervigilant? Not that I can recall. Was there evidence in all of the corroborating materials that in fact he went to his brother to quell fear, to subdue the fear? Yes. That was and that his brother was the place that he went for comfort. He was the source of comfort for him. Yes, yes. And support. Yes. Objection leading. Sustained as to the form of the question. What? Was there corroboration that over the course of his childhood and adolescence, Erik Menendez went to Lyle Menendez for emotional support? Yes. for protection. Yes. Was there evidence he went to Lyle on numerous occasions to intercede with his father that he was afraid of? Yes. Was there an evidence in, or was there any evidence in all of the materials that were submitted to you that Erik Menendez would go out of his way to try to avoid contact with Lyle? No. Was there any evidence to the contrary? Yes. That he would seek him out? Yes. In reading the testimony and statements of witnesses who knew who knew Erik, did they characterize in a way similar to how Erik characterized it, what Erik's feelings were about his brother? They did. Was there a consistency between the way Erik described to you how he felt about his brother over his life and how witnesses observed his feelings for, or expressions or feelings for his brother? Yes. There was an admiration for his brother expressed by Erik Menendez and others who observed that in him as well. He looked up to his brother. He wanted to be more like Lyle, not only because his father told him, "Why can't you be more like Lyle?" but because he truly did look up to his brother, and they didn't have a close relationship specifically early on because the parents kind of, separated them and put them, pitted them together like, "Why can't you be more like your brother?" And things of that nature, but he still saw his brother as a kind and gentle person going through the same things that he was going through and as someone that could save him potentially from the abuse when he saw his brother had a much better relationship with Jose. So that's another reason why he was able to leverage Lyle, or thought he could leverage Lyle, to get a response because Lyle had a close relationship with his dad and he was almost out of the house. He was almost an adult gone off on his own, but not quite. He had to finish college, but he was almost there because he was already living on his own. Yet, here we are. Anyway, so are those feelings and behaviors that we've just been discussing of Erik Menendez towards Lyle that you would expect from someone who had been traumatized by his older brother? No. Were those feelings and attitudes that were expressed concerning Erik and his older brother markedly different than the feelings and attitudes that people observed Erik have concerning his father? Yes. Now, when Mr. Kahn was questioning you about corroborating evidence, did he leave out the two photographs that are sitting in front of you on the witness stand? Yes. And one of those exhibits is 352A and 353A in this case. Yes. And what are those? There are two photographs of Lyle and Erik Menendez naked. One in a bathtub and one is standing with what appears to be a bathrobe. And the one that you're holding now, can you read the number on the back? There's more than one number on the back. Look for the 95 label. So, Exhibit 353A, says the witness. Ms. Abramson says that's 353A, and that's a photograph that you recognize as Erik Menendez. At least that's been identified as Erik. That's been identified as Erik Menendez. And he testified that that was him? Yes. And he has this birthmark on his arm that was apparent in the photograph? Yes. And the other photograph is 352A? Yes. Do you understand that was testified to be a naked photograph of Lyle Menendez? Yes. Did you consider the existence of dating from 1976 of those photographs, the two photographs, to have any significance in your determination that Erik Menendez, the source of Erik Menendez's post-traumatic stress disorder, was sexual molestation by his father? Yes. These photographs are consistent with that. Taking nude photographs of your children to have a little keepsake in your private little stash of stuff in your bedroom. That's weird. And you were asked by Mr. Kahn If in reviewing the medical records there was, I don't want to use the word proof, probably can, proof of molestation? I was asked that. Are you aware of the literature in the field of child molestation that indicates that there is a very, very small percentage of cases where there is physical proof? Objection, irrelevant, argumentative. Sustained. That's bogus. That should be allowed in. You're aware of the testimony of Dr. Carrie English in this courtroom? Objection, irrelevant. Sustained. In the medical records of Erik Menendez, was there anything that you noted that was of significance? Yes. And what was that? There's a report by Dr. Katz in 1977 regarding, I believe it's a bruised, or I think it's characterized as a bruised uvula and posterior larynx of Erik Menendez, the back of his throat. He has proof of a bruised throat and larynx. Yeah, you know what that's from, so we don't have to say anymore. And the existence of that hurt or bruise doesn't prove sexual molestation, does it? No, it does not. It doesn't disprove it either. Correct. Why did you find it significant? It's significant because it's one more piece of information that certainly would be consistent with a pattern of childhood sexual molestation. In your opinion, is that bruise consistent with forcible oral copulation of an adult penis into the throat of a small child? Yes. You can't say for sure that's what caused it, can you? No, I cannot. But it could have been. Could have been, says the witness. Was there anything specific in the records of Mrs. Menendez's conversation with her therapist in 1989 that you thought was significant on the issue of child molestation? Objection, irrelevant, Evidence Code 352. Sustained. I'd like to be heard later, Your Honor. Sure, says the court. Now, you mentioned yesterday in your response to some questioning from Mr. Khan concerning hypervigilance, I believe, that there was research being conducted by a man by the name of Blanchard. Yes. And did you last night, in fact, identify a particular research study dealing with the with the connection between hypervigilance and this hyperreactive response? Yes. Could you tell us what that study is by name and when it was conducted? There were numerous studies, not just a single one. But there was one article, I believe, that talks about the studies in a book that you have in your hand. Yes, says the witness. First of all, would you identify the book? He says the book is called The Neurobiological and Clinical Consequence of Stress from Normal Adaptive to Post-Traumatic Stress Disorder. The editors of the book are Mark J. John? I don't know. Friedman, Dennis Charney, and Ariel Yellow Dutch. That's what the court reporter heard, so that's how she spelled it out. The title of the article pertains to Chapter 16. The title of the chapter is Psychophysiological Evidence for Autonomic Arousal and Startle in Traumatized Adult Populations. Has me going. This has me thinking because I am currently being evaluated for POTS, which is an autonomic thing. And as I've spoken about before, I was in an abusive marriage. So I wonder if the two are related, but we don't need to go there. I think I've had POTS for a lot longer, but it's definitely progressed to debilitating levels at this point in my life. It never used to be this bad. Anyways, moving on. There are three authors of this research: Annabelle Prinz, Danny George Koltupek, something, I don't know, and Terrence with two R's, M as in Mother Keen. Okay. Well, what does that have to do with Blanchard? Blanchard is summarized in this chapter since he is one of the authors who did many of the early studies looking at laboratory-based studies of hyperarousal, fear response, and trauma-specific recognition of stimuli associated with different types of traumatic events that I talked about yesterday. Okay, let's see if we can do this in English, okay? I'm sorry. Oh no, you were fine there. Here's the question. In the most ordinary language possible, would you describe what it is that these studies are studying? I would object at this point, says Mr. Khan. It's beyond the scope of cross examination. I didn't get into the biology. The court says, beyond the scope of cross examination, and I didn't hear the rest. I didn't get into biology. You don't mean cross, you mean redirect. I'm sorry, says the court. I think counsel means it's beyond the scope of cross, says Mr. Khan. Never mind, says Mr. Abramson. The court says, as to the biology of aspects of this, yes, says Mr. Khan. Ms. Abramson says, Your Honor, unfortunately, biology is not separable. The court says, what is it that you're asking? Mr. Khan says, I'm asking to ask the witness to describe basically the findings of this study having to do with hypervigilance and the accuracy of hypervigilance and the hyperactivity in their response. I think the question yesterday, the court says without arguing it, the general area was touched upon in cross-examination, so you may inquire. Wait, what? He's letting her inquire about it. Okay. And it said Mr. Khan here, but I'm pretty sure that was Ms. Abramson talking. They do that sometimes. Yeah, so Ms. Abramson says, thank you, Your Honor. Now, your mission is to describe basically what this reference is researching in simple English. What these studies, or what this series of studies summarized in this chapter did very basically was to take groups of people who have PTSD and groups of people who don't have a type of PTSD and study them in a laboratory. What they want to know is for the persons who have had a history of trauma, do they have a faster recognition of stimuli that have something to do with their trauma experience? Is their recognition faster than the people who don't have that traumatic experience and don't have PTSD? That's the basic difference. They're trying to see who recognizes things connected to trauma faster, and what are the differences between the two groups of people who have either similar experiences or dissimilar experiences that are matched on the specific control. That's one part of the study. Second part was real simple. They used a number of different physiological measurements, things like heart rate, blood pressure, skin conductance, respiration, and then they carry out the study. So they take the group that has PTSD and they give them different kinds of stimuli. Some of them are auditory. Some of them are more ideographic or specific, special to their. Ideographic is a simple word? Okay, says the witness. They give them presentations inside the lab. They look to see what happened. Here's what happened for people who have post-traumatic stress disorder, whether they're Vietnam combats, motor vehicle victims, World War II veterans, Korean veterans, Israelis, subject to various kinds of experiences, if they have faster recognition of trauma-specific stimuli and their physiological arousal increases. Okay, they recognize what we've been calling cues, right? Yeah. And they recognize them faster than people who have not had trauma? Right. And does that indicate the person of hypervigilance? Or the presence of hypervigilance? Yes. They get more upset too. Haven't got to the second half yet. So she says, so they recognize cues. They're hypervigilant for cues, and this is measured now in the laboratory. Yes. And on the other side, when they see the cue, they react much higher? Yes. So the non-traumatized group, they see cues eventually, don't they? They're just slower. Right. And they don't react as much. Right. But I take it the study's designed in such a way that the non-traumatized group would react? Sure, they react. It's not something that's totally neutral. They have continuous measures of these things. The question is, what's the difference? So these studies measured both hypervigilance and the tendency of people who are traumatized to hypervigilant reactions. Yes. Of a more extreme emotional response. Yes. And this is measuring the biological aspect of that response. Yes. Have there been studies before that measured clinical aspects, people's feelings as they described them? Yes. And the behavioral aspects, people's actual behavioral reactions as they engaged in them? Yes. Things like what you said, the Vietnam War vets would hear a car backfire and dive for the dirt? Yes. And that's behavior that shows overreaction? Yes. And this study would indicate you'd also have a higher pulse rate and heart and all that other stuff. Yes. I want to focus on notions of hypervigilance and accuracy, okay? Yes. I want to use the example for a moment go back to the example you gave of the people who had been in a hotel fire. Yes. Okay, I want to give you a hypothetical. Let's assume that those people had come to a meeting in a hotel as you've described. Yes. And they've engaged in behaviors that appeared hypervigilant. Okay. Such as checking for the nearest exit, making sure there were smoke alarms, seeing where the windows are. Those things that you've described are behaviors that demonstrate hypervigilance. Yes. Now, let's say the fire alarm bell goes off in the hotel. Mm-hmm. Is a fire alarm bell an accurate cue that there might be a fire? Yes. Does the fact that a fire alarm bell goes off always mean the building is burning? No. Would you expect these people in this hotel room with a fire alarm going off to react in an extreme way? Absolutely. Would you expect a person who did not have the experience of being in a hotel fire that to such a person that they might say, I wonder if that's a real alarm? Yes. Would you expect the hypervigilant hotel fire victims to not even go through that process of wondering if it's real, but just reacting as if it is? Yes. Now, in fact, it could be the case that the fire alarm system is malfunctioning. Yes. So they can be wrong. Correct. But this doesn't make them inaccurate that they read the cue being a fire alarm means fire. Correct. Now, if hypothetically a person had been told, go to your room, and then was molested on numerous occasions in the past, hypothetically, is that person then heard, if that person then heard the molester say, go to your room, is it accurate to read that as a cue that the trauma may repeat? No. That's an accurate reading? Yes. Does that mean that for sure the person's going to get molested? No. That depends on somebody else's behavior, doesn't it? Correct. Hypothetically, if a person had been threatened over the course of their life, that if they revealed a particular secret, they would be killed, and then they revealed the secret, and the person who threatened them appeared angry and unrepentant and threatening in tone and actions and indicated they would continue doing offensive behavior, is it inaccurate to read that as a threat? No. Objection calls for speculation, no foundation, improper, hypothetical. Overruled. The answer is no, says the witness. The answer is no. Abramson says, so hypervigilant people can read the cues very accurately. Yes. And is the difference between the hypervigilant person reading the cues versus a stranger to the situation that the hypervigilant person knows the details of the trauma and knows what signals a trauma? Yes. In other words, in my hypothetical, if a stranger walked into a house and heard my hypothetical molester say, son, go to your room, it wouldn't mean anything to the stranger. It may not. Go to your room. Would that mean something traumatic is going to happen to a stranger? Not necessarily. Perhaps not at all. Yes. But to a person who's been traumatized following that, it means trauma. Yes. And they're right. Yes. Now, what studies that you just were describing, was this an attempt to understand why people who have been traumatized are hypervigilant and go from perception of cue to extreme reaction without any intermediate step? Yes. So you go from like your baseline normal to panic freak out in 0 seconds flat. Whereas a person who's not traumatized by that thing might just react normally and they don't react all the way to like an extreme. They might just be like, "Oh, okay, maybe that's something something." They might like rationalize or use logic in their brain to think about it first before they jump to that high extreme. Without, for example, the intermediate step in my hypothetical about the hotel, such as, is that a false alarm or a real alarm? Yes. It has long been understood that this hyperreaction is a product of what you described as these folks being hyper aroused to begin with. Yes. You talked about the idle screw being turned up. That's correct. It takes less to set them off to a greater degree. That's correct. Now, in your evaluation of the events of the last week before the shootings from a PTSD perspective, in your opinion, based on what Erik described, were there a series of occurrences that kept setting the idle screw higher and higher? Yes. So the tension kept rising and rising. That like on edge feeling where you're in the house, but everybody's like not talking to one another. They're mad at each other. You don't know where each other are in the house and you're trying to avoid one another. That's going on right now. And the tension just keeps getting worse and worse. Every time you do have an interaction with the parents, you find out something more that's awful, or you have another awful experience with them, like pulling Lyle's hair off in front of Erik. Were there a series of occurrences that made him less able to cope with perceived threats of trauma than at any time previous in his life? Yes. And specifically, was there a particular coping mechanism, as he described his thinking to you, that was blown out, if you will, twice in the days preceding the shootings? Objection vague. Sustained. That's just foundational. I'm going to ask him what they are. The court says, well, you used a phrase that it is saying, Ms. Abramson says, all right, coping mechanism. Let's back up. You had testified about rescue fantasy? Correct. Is rescue fantasy the coping mechanism that Erik Menendez had? Yes. That he had held onto for a long period of time? Yes. Was it, from what you could determine, his most effective coping mechanism to get him through the trauma? Yes. And was it a coping mechanism that the fantasy was soon to be realized? Yes. When that mechanism disappeared, and in your assessment of his mental state to him, it disappeared when his father said he'd have to sleep at home, continuing in the future for some undetermined time? Yes. So that interfered with his using that to cope. Objection, leading and beyond the scope of cross. Well, it's certainly leading. All right. Did that undermine his ability to cope with the threat of trauma? Yes. Did he then quickly form another rescue fantasy? Yes. What was that? The second rescue fantasy was to go and to disclose to his brother Lyle what had happened to him, or what was continuing to happen to him. What was the rescue part of that fantasy? What was going to rescue him? Well, what was going to rescue him is by telling his brother he might get assistance from Lyle. So its potential assistance from Lyle was a fantasy that there might be a rescue. Yes. What happened based on your assessment of that information that he gave you? What happened to that? The substitute rescue fantasy that week? I'm not sure what your question is. Well, this first rescue fantasy disappeared when his father said to come home. Yes. The second rescue fantasy had to do with Lyle and was somehow going to help him, with Lyle somehow going to help him? Yes. Was the help he expected that Lyle would talk to his father and get him out of this mess? Yes. What happened to that when Lyle went to talk to him? Objection, improper opinion, sustained. Abramson says, did the reaction that Erik Menendez experienced of his father to the conversation with Lyle Menendez, okay, yes. Did Erik's emotional response to that indicate a sense that his rescue fantasy of Lyle was now destroyed? Yes. And if that rescue fantasy, as he described it, was destroyed, what adequate coping mechanism did he describe to you, if any, was left to him at this point? He didn't describe any adequate coping mechanism to me. So Lyle was his last resort. Going away to college was his first. Then, when that didn't work, going to Lyle. Ms. Abramson says, does that mean none? Oh, yeah, he had none. Okay, and then Ms. Abramson says, Your Honor, this would be a good time to take a break. The court says, all right, we'll resume at 11:15. Don't discuss the matter with anyone. Don't form any final opinions about it, and we'll start up again. So they take a recess. The court says, let's get the jury out. The jury leaves, and now we're going to have some argument here. The court says, you may resume. Ms. Abramson says, thank you, Your Honor. Oh, no, I thought we had some arguments. Sorry. I thought he was sending the jury out. They took their... That confused me. Never mind. They took a recess, and now they're back with the jury, so examination. Thought they were having arguments. I'm sorry. It looked like they were. I misinterpreted that. We are back with cross-examination, and the court says you may resume, as Abramson says. Thank you, Your Honor. Dr. Wilson, in his cross-examination, Mr. Kahn asked you specifically whether you were aware of eyewitnesses who saw with their own eyes physical assaults. Do you recall those questions? Yes. Now, Dr. Wilson, in your assessment of the causes of post-traumatic stress disorder and battered person syndrome in Erik Menendez, were reports of physical assaults by his parents the crucial factor? No. Compared to the degrees to which children can be physically assaulted based on the literature, what was the type of behavior in this family the most abusive aspect? No, is his answer. What? I don't get it. Oh, she's building off of that question. She's building off of this question first, which was in your assessment of PTSD and battered person syndrome, were reports of physical assault by his parents a crucial factor? No, and not compared to the degrees to which children can be physically assaulted based on the literature. Was that type of behavior in this family the most abusive aspect? No. So the stuff that's in the literature, the most abusive stuff, is not the crucial factor in determining he had PTSD. With respect to that behavior that you rated as most closely connected to the post-traumatic stress disorder, for example, what was, in your opinion, the form of abuse or maltreatment experienced by Erik Menendez that is most closely related to his developing the symptoms of post-traumatic stress disorder? Objection irrelevant and evidence code 352, says Mr. Kahn. The court says, hasn't he already answered this question? He answered it before. He said it was the allegation of sexual molestation. He's already said that. Ms. Abramson says, thank you, Your Honor. Court says, let's go on to something else. Ms. Abramson says, well, I'm just laying this as a foundation, Your Honor. Court says, let's get on to whatever it is you want to go to. Ms. Abramson says, would that be your answer? What the judge is saying? Yes, he's correct. And is the particular pattern of symptom clusters that Erik Menendez demonstrated both in the clinical reviews, testimony, and the testing particularly consistent with a causation of long-term sexual molestation? Yes. Are there other patterns of symptom clusters in PTSD that are more consistent with other kinds of trauma than sexual molestation? Yes. Patterns that he did not display? Yes. Now, just to return for one moment, though, there was a witness, was there not, who personally observed, at least with his ears, that there was a physical assault going on in the family? Yes. Who was that? Alan Anderson, who is a cousin of theirs. I don't know who his parents are. One of the Anderson, probably likely, no, isn't he junior to Bob? Isn't it Bob? I don't remember. Sorry, my brain is slow today, like I said. Um, there's there a brother of Kitty's with the last name Anderson, and I think Alan is that man's son. That man was the last remaining person in the family who didn't want the brothers to get out of jail. But he's deceased as of like last year, I want to say. Um, or was that sooner? I don't know. Something along those lines. So, anyways, Alan Anderson is a cousin. That was my whole point. Rambling. Next question. Ms. Abramson says, were there other behaviors apart from assault, apart from the sexual molestation that contributed, in your opinion, to the highest arousal and the fearfulness and the high anxiety component of Erik Menendez's PTSD that were present in the family from childhood? Yes. So there were other behaviors going on in the household displaying that they had PTSD. Objection irrelevant, evidence code 352, and asked and answered. The court says, I didn't hear the last portion of what you said. Asked and answered. I'm sorry. The court says, I think this has all been covered already. Ms. Abramson says, well, it has been covered, but I think the issue was raised in cross-examination. The court says, no, not in the way the examination was conducted. Ms. Abramson says, the symptom clusters that Erik Menendez demonstrated in all the ways in which he did clinically and in the tests, did they indicate whether or not he was particularly vulnerable to a fear response? Yes. And based on the research and the literature, are people with PTSD who are particularly vulnerable to fear response people where there is a history of not only trauma but terrorizing or threatening behavior? I would object, Your Honor. Evidence Code 352 and beyond the scope of cross. Court says, I'll permit this one answer. It's really material that was covered on direct examination and not touched in cross-examination. We would just be rehashing material that's been asked and answered. I'll permit this one answer. The witness says, yes. Ms. Abramson says, now, was there, with respect to things that Erik told you that you interpreted as symptoms of PTSD, were the nightmares, not just the fact that he had them, but the kind of nightmares, significant? Yes. How far back in the material available to you in this case, does evidence of nightmares go? 1990. Well, do you recall Diane Vandermeulen's testimony that she was aware of nightmares in 1982? I thought you were referring to professional stuff. Yes, it goes back further than that. Now, with respect to professional materials, you mean the materials prepared by various mental health professionals? Correct. You've indicated 1990. What is the source in 1990 for the information concerning the particular types of content of nightmares that Mr. Menendez experienced? Dr. Vickery's notes, says the witness. Was there an aspect to the content and those nightmares that made the nightmares particularly significant as a symptom of PTSD? Yes. And what was that particular content? Well, there's more than one content. The content of the nightmares contains both direct and indirect references to sexual molestation, and there's also specific content in terms of imagery in the nightmares pertaining directly to Jose Menendez. Beyond that, there's indirect references in the form of green monsters and green mask-like creatures chasing Mr. Erik Menendez, and there are many, many variations of that theme in different forms of contents. Poor kid. I hope his nightmares don't continue to this day. I hope he has worked through that part in his brain. Because I feel like your nightmares are things you need to work through still. Things you're not necessarily dealing with. And with respect to those nightmares, having to do with the green mask is a typical feature of those nightmares that the mask comes off at some point in the dream. Objection, irrelevant, and beyond the scope of cross-examination. The court says, I don't remember dreams being mentioned in cross-examination, so sustained. I think symptoms and the proof of symptoms were. Court says, well, not going back and going over all the materials all over again. Sustained. Are you kidding? She didn't say she was going to go back through all the materials all over again, but even if she wanted to, she should be able to. Ms. Abramson says, now you also testified that there was a somatic response to cues or references back to the sexual trauma in this case. Yes. And Mr. Khan specifically cross-examined you about the information you obtained from Dr. Vickery's materials about Erik Menendez having been describing the rough sex, the violent episodes with Dr. Vickery, and then throwing up. So he had a violent reaction after he wasn't even having the experience. He was just retelling the experience to Dr. Vickery, and he threw up from having to deal with those memories all over again. And the witness says yes. Mr. Khan asked whether or not it was your understanding that Dr. Vickery was just told that he threw up rather than having any evidence of it directly. Yes. Now, do you recall that there is something that Dr. Vickery observed directly? Yes. What was that? That Mr. Erik Menendez turned green while describing these episodes of rough sex. And then stopped the interview? Yes. Left? Yes. Later reported he had thrown up. And that's correct. Now, is another demonstration of a somatic reaction where the body is reacting automatically to trauma memory inappropriately. Well, strike that. Physical disassociation. Yes. Is falling asleep inappropriately a form of physical disassociation? Yes, it can be. Is there information in Dr. Vickery's notes from 1990 about that? Yes. With reference to Erik Menendez? Yes, there is. Did you find in that information that was significant in a session where there were symptoms here of PTSD? Yes, I did. What was that information? The information is that Mr. Erik Menendez would start to fall asleep as he was describing the episodes of particularly rough sex. The significance to me is that this is a form of dissociative reaction, meaning that the disclosure of the traumatic memory describing in detail the nature of the rough sex is so overwhelming, so distressing that he engaged in that dissociative response, which is to literally change his physical state. That is, to go to sleep as a way of avoiding confrontation with the material. He literally would just fall asleep before he would start to describe the rough stuff that he didn't want to talk about. It's a way that his mind, in a sense, is turning off his body so that the mind doesn't have to experience the pain of what he's reporting about those episodes of rough sex with his father. Now, in your opinion, Dr. Wilson, if someone were faking this information of rough sex to build a defense, would he go to sleep when he's talking about it? On the contrary, they better stay awake and pay attention. Was this something that Dr. Vickery noted happened repeatedly whenever he was engaging Erik in discussions about the sexual torture sessions? Yes. It was repeatedly observed that his body would seem to go to sleep describing these particular sessions of sexual molestation known as the rough sex. Now, you had mentioned on cross that there is a distinction between so-called normal disassociation and pathological disassociation. That's correct. A quick example, what's normal disassociation? Common example, sleepwalking, freeway hypnosis, where you forget how you got from A to B. With respect to the information in this case, are there examples? We'll strike all of that. Is The going to sleep in Dr. Vickery's interviews an example of pathological disassociation? Yes. Are there are there others concerning this case? Yes. What are the others? Some of the others include out of body experiences, which is known as depersonalization dissociative reaction, where the person views himself as if out of their body, looking down on what's taking place, for example, in terms of sexual molestation. Other examples include similar depersonalization dissociative reactions, where Mr. Erik Menendez reported looking at himself out of the closet into the room. Other examples of depersonalization, dissociative reaction, seeing himself sort of up in the corner near the ceiling. These are some examples of his dissociative reactions. Now, just in general, is it normal for teenage boys to not want to talk about sex? Is it normal for teenage boys not to want to talk about sex? Yeah. No, they like to talk about sex. Is it why you ascribed Erik Menendez reported discomfort talking about sex to an avoidance symptom on his part? Precisely. Avoiding things that might make him think about sexual trauma. Absolutely correct. Now, with respect to the literature concerning the symptomology of PTSD in people who have been traumatized repeatedly by another human being who are still in the traumatic environment, okay, which would be the literature on battered women and the literature on abused children. Yes. All right. How frequently in those populations of studied people is hypervigilance studied as a symptom? Very often. And if in this case, Erik Menendez had not reported to you thoughts and feelings and behaviors that you interpreted as hypervigilance, would that have caused you some difficulty with respect to your conclusions in this case? Yes, it would have. Would you explain that? Yes. Because Erik Menendez had not reported to me these symptoms of hyperarousal, hypervigilance, being keyed up, dissociative like reactions in association with traumatic experiences, or the intensity of his intrusive recollections connected with hyperarousal, it would have made me suspicious because the learning connection is very specific. There's trauma specific learning taking place during these molestations. So, had there been no description of hypervigilant arousal, hypervigilance, his attentiveness to specific cues, tone of voice, footsteps, pressure on the stairs, slamming of door cars, slamming of doors coming to the house, measure of speech, greeting of his mother, friendly, not friendly, etc. Those kinds of very specific examples that he provided me, if those types of cues connected to hypervigilance and hyperarousal had not been reported to him or been reported by him, it would have made me very suspicious as to whether or not he's telling the truth about what happened. Interesting. So that hypervigilance is a huge key component as to him, as to, proof, if you can call it that, that he was abused. Now, Mr. Khan asked you if hypervigilance was a necessary feature of PTSD in general, correct? No, that's not what he asked. I'm sorry, what did he ask? He asked whether or not hypervigilance was necessary as one of the 5 symptoms of the decluster in order to make a diagnosis. I thought that's what I said. No, it's not what you said. Well, isn't it? There are many people with PTSD who don't have hypervigilance. Well, that's an unknown question. Maybe. Maybe. With respect to the kind of trauma you found here as a causative aspect of PTSD, does it have to have hypervigilance for you to believe it? Correct. And with respect to hypervigilant arousal, is that also an extremely common component among these populations of PTSD sufferers who are still inside the traumatic domestic relationships? Yes. Is helplessness as a symptom of PTSD as well as a symptom of battered person syndrome also an extremely prevalent effect in those situations where those people are involved in trauma from interpersonal relationships and they're still in the trauma inducing relationship. Yes. Now, can you characterize, Dr. Wilson, based on the research materials, the nature of the typical reactivity or reaction to trauma specific cues of people suffering from post traumatic stress disorder? Yes. And would you? Mr. Khan says, I would object. I think this was asked and answered previously. The court says, yes, it has already been covered. Ms. Abramson says, well, I think it was questioned on cross-examination. Court says, all right, let's just very briefly do this because we keep repeating the same things over and over again. Why doesn't he want specific examples of things coming in? He's very hesitant to let the defense, question witnesses. Mr. Khan says, I'm sorry, the question is, Ms. Abramson says, Mr. Khan was asking you if, for example, on Saturday night, as Erik Menendez described it, he was sitting on his bed and his father was banging on the door and he froze, and you indicated that freezing, being unable to do anything, is one of the dual ways in which people who are aroused and frightened react to a threat. Correct. And that's not just the way people with PTSD react to a threat. No, others can act that way as well. Fight or flight applies to everybody? Sure. And freezing is a form of flight. Yes. It's a way of you don't do anything, you disappear inside yourself. Correct. And fighting is the other survival mechanism, right? Yes. However, with respect to people with post traumatic stress disorder, I think what you talked about before is the literature shows they tend to react and highly react. Is that correct? That's a typical response. Yes, that's a typical response. And just briefly, as His Honor has indicated, could you characterize the way in which people with PTSD react that is linked to the PTSD? Sure. Objection vague. Do you understand the question? Asked the court. The witness says, yes, I do. The way people with PTSD react is one of extreme emotionality. They tend to become panicked. They go into what I frequently term is a survivor mode, thinking to deal with the level of the perceived threat in a given situation. It's sort of like automatic pilot responding. They go into the survival mechanisms of fight or flight. In the fight component, it's the panic. It's going immediately into the tense, emotional overreactivity, which often bypasses more reflective thinking. Abramson asks, now, Erik Menendez reported, did he not, both to you and Dr. Vickery, and his testimony in both trials, that what he experienced emotionally after his father told him to go up to his room and he started walking, and then particularly when his brother came back and said, it's happening now, was extreme panic? Yes. With no thought other than, hurry, hurry, I've got to get to that room before they get me. Yes. So he's always been consistent about that. With once they finally admitted that, yes, we did it, and here's why we did it, then they've always been consistent on their word. They lied originally because they're kids, and they thought they didn't think that anything of it, I guess, probably. Like, oh, well, we're not in trouble, so all right, let's keep on keeping on. Although it was killing them both on the inside. Until the point where Erik couldn't take it anymore and he went to go see Oziel, unfortunately. So yeah, that's survival mode. Is it reflection? No. Is that deliberation? No. And if, given the history you took from him and he has talked about now for 6 years, if he had not indicated that he reacted to these cues coming from the trauma inducer with extreme panic, what would have been your reaction? If given that history? Yeah, I would have been very surprised. Would that make you suspicious? Yes. If he did not indicate he had had a typical PTSD reaction? Yes. Unless there was some other reason externally that would have stopped that kind of automatic response on his part, given that history? If the house had blown up at that moment, sure. Is hypervigilance something that goes off and on? No, it's a chronic state in people with PTSD. Does the intensity of it increase as growing perception of that threat increases? Absolutely. Mr. Khan asked you a series of questions about whether PTSD makes people homicidal. Yes. Does it? No, it doesn't. People with PTSD are no more dangerous than anybody else, are they? We don't know for sure. Clinically, we don't think so. Are they, however, especially vulnerable to react to fear inducing stimulus? Absolutely. And I think you mentioned in your cross examination yesterday that the only situations in which there appears to be some linkage consistently between the effects of trauma and homicides in the area of parricide. Would you repeat that question for me again? Well, you recall yesterday you cited, yes, the parricide literature. Yes. And indicating there appears to be a causal link between child molestation and abuse. Yes. And those homicides. Yes, that's correct. What is parricide? Parricide is the killing of parents, or parent, or parent. So one or two. Even in those cases, is the history, I'm sorry, start that all over again. Even in those cases, is the theory that children who have been abused and molested and have PTSD are more homicidal? No, they're not more homicidal. They have a history of child abuse coupled with other factors in their trauma history. And what is understood to be the linkage, if any, between that history of abuse and the homicides in the parricide cases that have been studied? There's several linkages in the studies that have looked at this question. One is that there's this chronic history of childhood abuse, and number two, that the link between the abuse and the parricide is often related to an attempt to extricate or escape from the relationship that's abusive. Are those cases also typified by some family crisis concerning the child's desire to escape from the abusive relationship? Yes, and that's very much the typical pattern. Are those cases typified by the child victim of abuse reacting to a typical PTSD state? Yes. Of panic? Yes. To perceived threats of additional abuse? Yes. Is there anything in the parricide literature that indicates a pattern of children killing their parents for money? I can't find anything like that in the literature, no. I have nothing further, Your Honor. Recross, asked the court, and Mr. Khan says yes. Mr. Khan is up for recross, and he says, you were asked, Dr. Wilson, a question concerning the battered person syndrome. And you said that the battered person syndrome is a type which is now being used. Is that what you said? Yes. It's not just being used in writing, is that correct? I'm sorry? It's not just a term being used in writing, is that correct? In writing? Yes. No, it's starting to appear in writing. That's what I'm asking you about the other day, doctor. Where did you find the term in writing? Abramson says, this is beyond the scope of redirect. Court says, doesn't seem like it was covered. Mr. Khan says, yes. Well, he testified that battered person syndrome is a term which is now being used. On redirect? Yes, on redirect. Okay, you may answer the question. The witness says, what's your question again? Mr. Khan says, you said that the battered person syndrome is a term that's now being used. Is that correct? Yes. I asked you is it being used in writing by any psychiatrist or psychologist in this country? In writing? Yes. That's what you asked me on cross-examination? Yes. Yes, and I answered no, it wasn't at that time, but it's about to be. Yes. I'm asking you about what's been published so far in this country. That's not the same question. This is argumentative. The court says, counsel, you're arguing. I'm sorry. Court says, you're very argumentative at this point. Ms. Abramson says, mea culpa. Court says, the objection is sustained as to the form of the question. Rephrase it. Mr. Khan says, my question is there anything in writing at this time published by any psychologist, any psychiatrist in this country using the term battered person syndrome? I answered that for you before. The answer is no. You said that children have little control over where they live until they reach the age of emancipation. Is that correct? Yes. Objection misstates it. Overruled. Mr. Khan says, what age are you referring to as the age of emancipation? 18. Maybe so, but he still was being controlled by his father. They both were. Lyle was, 21? And Erik was 18. They were still both very much being controlled, their lives being decided for by their parents the whole time. So Erik had no choice in the situation. It was, this is how it is in the house, and that's just it. If you argue, you're just going to get punished, and it's going to happen anyway. So you might as well not argue. And you recognize that at that point, many young adults do have control over where they live. Is that correct? Objection, Your Honor, calls for speculation. The court says that was the nature of the inquiry on redirect. Ms. Abramson says the question was until they are emancipated. Court says okay, overruled. Witness says yes. Mr. Khan says concerning the battered women syndrome, it is true, is it not, Dr. Wilson, that the battered women syndrome is found nowhere in the Diagnostic and Statistical Manual of Mental Disorders? That's correct. The American Psychiatric Association does not recognize this battered woman syndrome as a mental disorder. Is that correct? Ms. Abramson says, Your Honor, I'm going to object given the court's ruling on this case. The court says, overruled. The witness says, that's correct. Mr. Khan says, now concerning your interview with Erik Menendez, you indicated that Erik said or made reference to the use of a license when he went to San Diego in more than one interview. Is that correct? Yes. And Ms. Abramson said that I only pointed your attention to one of those sessions in which Erik Menendez made reference to the issue of the license. Is that correct? Yeah, that's correct. Now, do you recall the date of the two sessions in which he made reference to the use of the license, and specifically in regard to the NRA mail? The date of the interview? Yes. 12/9/95. 12/9/95 is the date of the first interview or the second interview? No, that's when the reference appears to using the license. Well, didn't he make reference to the NRA mail on a prior date? I believe he did. Okay, what date was that? I'm not sure. I don't have it referenced right now. Let me ask you, says Mr. Khan, to turn to tablet 5, page 19. Okay, just a moment. Yes. Is this the date in which he made reference to the NRA mail? Which date? He says, yes, there's a reference to that there. Okay, all right. So you have a reference on table 5, page 19. Is that correct? Yes, page 19, right. And then you have another reference on table 6, page 16. Is that correct? That's correct. Your Honor, I have a Xerox copy of those two pages. I would like to mark it as, I believe it would be 405. Ms. Abramson says, I would object to marking that. The court says it certainly could be marked. That's all that's being done at this point, 405 A and B. Mr. Khan says, okay. Now the top of the page is a Xerox copy. Do we really need to say Xerox copy? Can't we just say copy? A Xerox copy of tablet 5, page 19. Is that correct? Yeah. Okay, would you please write at the bottom of the page the date on which Erik Menendez made that statement to you? Down here? Yes, please. The witness does it. That is November the 18th of 1995. If you would turn to the second page of the two-page document that I just handed you, can you tell me what date that Erik Menendez made that statement to you? 12/9/95. Would you please write that date down on that page? The witness complies. All right, thank you. Yes. Now, when you interviewed Erik Menendez on November the 18th of 1995, and he made reference to the trip to San Diego, what did he tell you on that date concerning the reason for not using his own driver's license? Ms. Abramson says, Your Honor, this has been asked and answered. Court says, well, it was covered on redirect just this morning, overruled. You see how easily he just dismisses her when she has an objection, but not the other way around. The witness says, I'm not sure I understand your question, Mr. Khan. Mr. Khan says, yes, on November 18th. Yes. You interviewed Erik Menendez concerning the trip to San Diego and the purchase of the shotgun. Is that correct? Yeah. And he made a statement to you concerning not using his own driver's license. Is that correct? Yes. And what did he tell you on that date concerning why he did not use his driver's license? Well, at the bottom, E says he couldn't use own license because Jose might find out if got an RA mail or something. By E, you're referring to Erik. Erik. You would read, would you read the rest for us? He continues on and says Erik couldn't use own license because Jose might find out if got NRA mail or something. Is that correct? Yes. Was that the thing that he told you about why he did not use his own license on that date? Well, no. There's another entry above that. What is the entry above that? He said, used Donovan Goodrow's driver's license. And then there's a line. Erik had to get into bars, went to Big Five in San Diego. Meaning he has a fake ID. Right. So he indicated to you that he had a driver's license belonging to Donovan Goodrow, and he used it on his date. Is that correct? He was using the Goodrow license to get into bars and things. Witness says, yeah. Did he make any other statements to you on November the 18th as to why he did not use his driver's license? Let me look for a sec. I think this is the only entry, but let me double check. That appears to be it. And is that your recollection too, as you sit here today, that the only statement that Erik made to you on November 18th of 1995 as to why he used or did not use his own parents or his own driver's license is that he is what he said in these two paragraphs? Ms. Abramson says, I'm going to object, misstates what's in the paragraphs. Overruled. The witness says, please repeat the question for me. Yes. As you sit here today, is it your recollection that the only discussion that Erik had with you concerning why he didn't use his driver's license is what is reflected in these two paragraphs? Ms. Abramson says, I'm going to object to that. That's a different question. The other one was that day. Court says overruled, overruled. The witness says, okay, I'm getting confused with this overruling. One more time, if you would, please. Mr. Khan says, let me rephrase it. The witness says, sure. Mr. Khan says, I would like to tell you, or I would like you to tell us, what is your recollection concerning the full discussion with Erik Menendez on November the 18th of 1995 concerning why he did not use his own driver's license? It's what I testified before earlier, that he didn't use his own, as indicated on the bottom, because he was afraid his father would find out if he had his own license because he might get NRA mail. And if he got such mail, it would be traced back to making a purchase of a gun, and his father could find out about it, and it could create a problem for him. makes sense in a kid's mind. That was a full discussion that you had with him that day concerning why he did not use his driver's license. Is that correct? Yes. That's in reference to this note. Okay. And then you went back to see him 3 weeks, approximately 3 weeks later on December the 9th. Is that correct? That's right. Now, what did you do with your notes from November the 18th after you made these notes? I believe it's tablet 5. I don't know what your question is. Yes, after you took these notes from tablet 5, did you provide these notes to anyone? No. Objection, Your Honor. Overruled, says the court. Witness says no. You kept them to yourself? Of course. Turning then to December 9th of 1995, you again had a conversation with him concerning going to San Diego, purchasing the shotguns, and not using his own driver's license. Yes. What was your reason for discussing that again? I think they've answered that before, that I was going back over the events of the week in August 20th, starting with the 18th and progressing all the way up through the 20th. And it was on December the 9th of 95 that he told you, as reflected in your notes, that he lost his wallet in the spring, which had his ID card. He got a ticket before for not having his driver's license, and even if he had his own identification, he wouldn't have used. He was afraid that his father would find out. If got stuff. In reference to NRA magazine, is that correct? Yes. And was there any other conversation you had with him on that date concerning why he did not use the driver's license? Let me look for a minute. I don't recall that there was, but I'll double check. The question again, I'm looking at the next page. Ms. Abramson says, yes. Did you have any other discussion with Erik Menendez on December the 9th of 1995 concerning why he did not use his driver's license other than what is reflected in tablet 6, page 6? That appears to be it. Now, you indicated in your testimony that the court says, let me ask, how much longer do you think you'll be? Probably at least a half hour, Your Honor. Mr. Khan says, at least a half hour. Ms. Abramson says, Your Honor, I'd like to ask. The court says, let's take our recess and we'll resume at 1:30 with the understanding one juror has something to do during the lunch hour. It might be a little longer, but we'll recess until 1:30 and ask everybody to be back here then. We'll discuss the matter. Ms. Abramson said, could we have some idea? The witness has a plane reservation he's now going to have to change. So court says, yes, we'll talk about it. The jury exits the courtroom. So now we're going to have arguments without or outside the presence of the jury. So the court says, as far as cross, you think about half an hour. Mr. Khan says, between half an hour to an hour. Court says, okay, we have a juror who has a problem he has to deal with during the lunch hour. It's problematic whether we start precisely at 1:30. When he's ready to proceed, we will. Ms. Abramson says, Judge, what I'm hearing is he's not going to make the 3-something flight either. Court says, doesn't sound that way. Ms. Abramson says, it's the old red eye again. Mr. Khan says, there is one additional matter. Perhaps we can take it up now. The court says, yes. Mr. Khan says, so that I know there will be an objection. One of the things we want to bring out, the bailiff says, could I take the jury out? The court says, yes, sure. The jury leaves premises. The court says, yes. Mr. Khan says, one of the things that I would like to get into in cross-examination, because I think it's relevant and goes to the basis, or goes to the bias, for potential bias of this witness, that the jury should be appraised of, is the fact. It's my understanding that this witness is staying at Ms. Abramson's home the period of time that he has been here. Now, I think that it's necessary for us to explore the nature of this situation, and that is if he is in fact staying on a daily basis at counsel's home, it goes not only to the question of compensation he has received in this case because he indicated first it was 5,000, then he later changed it to 13,000, and he made no reference to the free room and board on top of that. So, if that is the case, that is something we feel is necessary to go into. Experts get their travel paid for all the time. You don't expect the expert to have to pay for their travel to come to testify for you. You definitely have to pay them for that. So travel, room and board, food, things like that, they're still going to have to get on their own. But that should be um a part of it, you know what I'm saying? I hope. So if that is the case, that is something we feel is necessary to go into because not only because of the financial aspect of it and if this benefits him from this arrangement, but also because of a sense of indebtedness and the relationship that is fostered by that type of situation. I think when a person stays in that type of situation, there's naturally going to be some sense of obligation or appreciation, which may very well be reflected in his testimony. And it's something the jury should factor in evaluating his testimony. The court says, what is the defense response? My suggestion to you is think it through as to how it will play out overall as to whether you gain or lose by such an answer. What? Ms. Abramson says, you want to talk about how he kissed my baby goodnight last night? The court says, whatever it is, think it through as to the explanation as to why he's staying there rather than a hotel because he hasn't been paid enough. I understand that, says Mr. Khan. Ms. Abramson says, you got it, Judge. The court says, it might show his bias, but it also might show some other things that really won't prove much. I understand that, says Mr. Khan. The court says, defense wish to be heard. Ms. Abramson says, we object. And the obvious answer is, as this court knows what's happened in this county, is there's not enough money provided for expert fees. And there's only one hotel that anybody is allowed to use, and it's too far away to make working with the witness reliable. So it's too far away for her to be able to talk to her witness. And my husband's there to chaperone, so I guess I could bring him in to testify, and it's silly, Judge. The court says, well, it does have the tendency to bring in a lot of extraneous material, and that's my concern. That really won't prove anything. So at this point, under 352 of the Evidence Code, I'll foreclose getting into it. So he cannot bring up the fact that this witness is staying in Ms. Abramson's home. But he's also not been able to bring up certain things, and he still kind of sneaks them in because he plays dirty like that. So we'll see what happens. Okay, we'll be in recess until 1:30. So that is where we end for today. Thank you so much for watching. Again, I think this one is going to be late, but at least you guys are getting 2 this week, and I'm going to try to get back to our regularly scheduled programming as soon as I can. It's just, I'm catching up. So apologies again for that, but thank you for being patient with me. And I will see you guys in the next one. Take care. Bye now. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.